The Supreme Court consists of 5 justices. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. The vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year
Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We are here at the time set for oral argument in case number 2025-0434, Associated General Contractors of North Dakota and American Concrete Pavement Association, North Dakota Chapter, Inc. versus City of West Fargo. Appearing this morning for the appellant is Nicholas Surma, and appearing Russ Hansen. Did I have that correct? All right. And arguing for the appellee is Mr. Howard Swanson. Sitting this morning on the court are Justices Jared Tufte, John Jensen, Douglas Barr, and we welcome District Judge District Hager, who is sitting in for Justice Mark Fries, who is disqualified from this case. Mr. Surma, when you're ready, you may proceed.
Thank you, Chief Justice McEvers, and may it please the court. North Dakota Century Code Section 4801.204 states, and I quote, "If the estimated cost for the construction of a public improvement is in excess of the threshold established under 4801.202.1, the governing body shall advertise for bids." The word "shall" in Section 4801.204 creates a mandatory duty that governing bodies, including political subdivisions, must competitively bid and contract for the construction of public improvements if the cost exceeds the threshold established under 4801.2-02.1. Yet despite this clear directive, West Fargo self-performed certain work on the Improvement District 2290 project, a public improvement construction project costing $1.3 million, well in excess of the $200,000 threshold established by statute at the time. Associated General Contractors of North Dakota and the North Dakota chapter of the American Concrete Pavement Association, who we'll refer to collectively as AGC, brought this action to have it decided whether political subdivisions, including West Fargo, can self-perform work on public improvement construction projects given the clear mandate in Section 4801.204 that such projects must be competitively bid. But before AGC's claims could be decided on their merits, West Fargo substantially completed the Improvement District 2290 project. Because the project had been substantially completed, the Improvement District 2290, the district court dismissed AGC's claims as moot. Two issues now present themselves to the court today. First, whether the district court erred in dismissing AGC's claims as moot, and second, whether the district court abused its discretion in denying AGC's motion to supplement its complaint. Addressing mootness first, this court has long held that it will decide moot issues if they are of great public interest and involve the authority and power of public officials, or if they are capable of repetition yet evading review. Under both exceptions, AGC's claims should be decided on their merits. The public interest exception clearly applies here. This court has said public interest means something in which the public or the community at large has some pecuniary interest or some interest by which their legal rights or liabilities are affected.
Mr. Surma, if we don't reverse the district court on denying AGC's motion to supplement the complaint, doesn't that mean the first issue that the city no longer has any interest? They're not the party who should be defending a statute that won't apply to them. They're not the right party to litigate something that they have no interest in anymore.
The city of West Fargo.
Correct. If we don't reverse on the motion to supplement, therefore the validity of 1257 would never be addressed. Right? And so that means the statute's not relevant to them anymore.
Well, West Fargo has argued that it has the authority under state law to self-perform these types of projects. So I do think that the issue is still relevant and presents itself.
Not if they have an ordinance, so they're not relying on that statute anymore.
Well, again, though, if they're arguing twofold, that they can they can perform the work under state law regardless of the ordinance. So I think that issue needs to be addressed of whether under state law West Fargo can perform this type of work regardless of the ordinance or not. I think the issue is still there for review and is within the public interest. You know, the legislature has enacted a pretty comprehensive competitive bidding framework that is intended in part to benefit the public. That's its primary purpose for several different reasons. I mean, there's the fraud and collusion and corruption purposes of those statutes, but there's also the purposes to invite competition among free market corporations and enterprises and ensure that public entities are procuring the best work possible for the best price possible. And I think that you know, when you're using public funds to pay for public work, that is something that is within the public interest and clearly falls within the exception if it's determined that this case is moot.
Is the city of West Fargo, is this a home rule city?
It is, Your Honor.
So why isn't this more like Pooch again? That this applies because it's less of an exception because it's a home rule charter city like Poochigan, the Poochigan case was on the vote. Why doesn't it make it of less interest to the public because it's just a home rule city?
So Poochigan addressed a ordinance that was specific to Grand Forks, and if you look at the Poochigan decision, the court clearly says in there that it did not involve a statute or a constitutional provision. It was a home rule ordinance. This case involves interpretation of 4801.2 that applies to every political subdivision, not just West Fargo. And I think that that's the important distinction of why Poochigan is not analogous to the facts here. It's because certainly the ordinance 1257 is an issue, right? I mean, we argued below that the ordinance effectively supersedes state law and that West Fargo does not have the authority to do that. But West Fargo is still saying that regardless of the ordinance, it has the ability to self-perform these types of projects under 4801.2. So the issue still presents itself in interpreting the statutory framework enacted by the legislature.
So, Mr. Surma, assuming that we would agree with you on issue one, that it's something that we should look at, does that also require us, because part of the court's rationale was that it was too late because it was past the time for summary judgment, but if we send that back, then should your client have another opportunity to make the argument to amend, or can the district court's analysis stand on its own for that second issue?
For the second issue, I think that we would prefer to have both issues resolved comprehensively in one proceeding. The validity of the ordinance and whether West Fargo can self-perform under the statute.
But if the court didn't abuse its discretion based on its analysis, what in the analysis would allow us to say the court abused its discretion?
Because the district court denied our motion to supplement to challenge Ordinance 1257's validity because we did not have standing, is what the district court found or concluded. Well, standing is a question of law. That this court could decide as a question of law that yes, AGC does have standing to challenge the ordinance, and the district court would have abused its discretion.
The court didn't rely on the timing of when the motion to amend was made?
It did in part, but I think that the two claims are related, and we cite in our brief the federal standard to supplement your pleading. The purpose and the goal is to resolve the controversy between the parties in one proceeding, rather for judicial economy, rather than having several piecemeal proceedings. And that was the goal in moving to supplement, is so that we didn't have to be back here in 9 months to a year on challenging the ordinance when it was there and had presented itself at that point. I'll also point out, Justice McEvers, to that end that, Ordinance 1257 is related to AGC's claims. Part of the issue in this case is that West Fargo is arguing that this type of work constitutes routine street maintenance, and that specifically the 2290 project was routine street maintenance. And in support of that contention, it submitted a declaration of City Engineer Dustin Scott that included a definition of routine street maintenance. That definition that Mr. Scott provided in his declaration is the exact same definition of routine street maintenance that West Fargo has now codified in Ordinance 1257. West Fargo is relying on a definition here that it is presumably going to rely upon in future cases, and for the sake of judicial economy and getting this completed in one action, I think it's preferable that the court address both the statutory interpretation issue and the issue with the ordinance in one proceeding. And since we're discussing the ordinance again, the district court erred in concluding that AGC lacks standing to challenge the ordinance. Century Code Section 322311 specifically confers trade or professional associations with standing to determine any question of construction or validity of any statute or ordinance that threatens to injure its members. We have two separate declarations from both of the plaintiffs in this case explaining how, taking away wholesale a large amount of work from AGC's members threatens to injure their members, and is also contrary to state law in the framework enacted in 4801.2. And I think that, Ordinance 1257 is clearly an effort by West Fargo to circumvent 4801.2 by giving the term routine maintenance a definition that fits West Fargo's interests. I think it's pretty clear that that's an attempt to effectively supersede the use of the term and the words routine street maintenance or routine maintenance under 4801.2. Going back to the mootness issue, we do cite in our reply brief several cases from other jurisdictions holding that questions involving public bidding are of particular public interest and have decided the cases on the merits, even though it's found that the cases are moot. So those cases are persuasive, and I'd encourage the court to adopt the rationale employed in those cases and enlisted here as well.
Mr. Surma, I know you're arguing that if we agree with you on either issue, we should address the merits. And I believe you cite Danzel for that. Why should we not, let's say you're correct. We say you're correct on issue one, and shouldn't we just remand it, let the district court address it first?
It is that is an option, Justice Barr, certainly. But, because we're interpreting statutes, there are pure questions of law presented, and so I do think it would be appropriate for this court to address the legal questions rather than have a remand and potentially then a subsequent appeal on pure questions of law. The second exception to mootness also applies. Again, we briefed the capable of repetition yet evading review. I think that the facts of this case bear out that the projects at issue are particularly short duration, 2 to 3 months at most. And if the city wanted to complete them quicker, it probably could. West Fargo has argued that, we should be seeking emergency injunctive relief. First, there's no authority to support, they haven't cited anything requiring that emergency relief is required. In fact, in Danzel, the court acknowledged that Danzel did not seek emergency relief, but still proceeded to address the claims on the merits. And as this court in Forum Publishing explained, injunctive relief in this context can be undesirable. On the one hand, the project is halted, that could potentially have an adverse impact on the public, on completing these public works projects. Or on the other hand, an injunction could be denied, and then we're in the same situation that we're in now. The project's completed, it becomes moot, and the issue remains unresolved. So, for those reasons, that exception to the mootness doctrine equally applies. And again, there's case law from other jurisdictions that we cite in our brief that supports that proposition. Turning a bit to the merits, West Fargo has, it's currently arguing that routine maintenance is an undefined term in statute, and therefore it has the ability to define that. The interpretation of words and phrases in statute, I think, is a core function of the courts. Cities are creatures of statute, only have the powers conferred on them by the legislature. And if you look in 4005.106, which lays out the powers that home rule cities have, nowhere in there is that they can supplement state law or define undefined terms in state law. Again, I think that's a core function of the courts under the powers expressly given to it in the Constitution and inferred to the judiciary by the Constitution.
Does the association have a different definition for routine maintenance?
Well, I think, words and terms in statute are supposed to be given their ordinary meaning. And in our brief, we cite some dictionary definitions of what is considered maintenance versus repair and things like that. And I think that in determining what is maintenance versus repair versus improvements, you take and consider all those definitions and their commonly understood meaning to determine what that is. I think here, in the context of a road project, maintenance is repairing a pothole or a small portion of the road. Here, this project is a wholesale reconstruction where the entire roadway is ground up and repaved. So I think, the commonly understood meaning of what maintenance is does not include that type of reconstruction that's at issue.
Thank you.
The question was also asked, is West Fargo a home rule city? It is, but nowhere in 4005.106 is there given to home rule cities the powers to supersede 4801.2. I think it's pretty expressly clear in the definitions of 4801.2 that a governing agency that 4801.2 applies to includes a political subdivision. So that in itself, shows that the legislature intended 4801.2 to apply to political subdivisions and could not be superseded. I'll also point out that, under section 10207 of the Century Code, the special provision in the statute that is enacted later is supposed to prevail over the general provision that was enacted earlier. Here, 4801.2 is the special provision that must prevail over the general powers of home rule cities to maintain their streets and things like that. So unless there are any further questions, that'll conclude my opening argument. Thank you.
Hearing none, thank you, Mr. Surma. And Mr. Swanson, whenever you're ready.
Chief Justice, Justices, Council, may it please the Court. The City of West Fargo is asking this Court to affirm the judgment of dismissal without prejudice. Judge Brady put a lot of effort into his analysis of this case. And let's start off right out of the chute about what he looked at in mootness. And these facts are not in dispute. The project's done. There's a full timeline here as to what happened. The plaintiffs brought a motion for summary judgment, and sometime after that, decided they wanted to amend or supplement their complaint. But during that time, the project had already been completed. The road's been repaired, rehabilitated. And I'll get into it later, but we do not agree that this was a reconstruction. That's an entirely different animal of a road project. But in this situation, we have substantial completion occurring on September 4th. The motion for summary judgment was April 18th. The motion to amend didn't occur until September 19th. This ordinance had nothing to do with this project. Short and simple. And the judge saw that. The judge analyzed that. In fact, the court was put into an interesting position if we accept AGC's argument, and that is, what's the court going to do? You can't go and rip up the road. You can't pay the contractors more money. You can't claw back money from the contractors. It's an esoterical question at that point, for which the court said it was moot. And the court then considered whether or not the mootness exceptions should apply. And in paragraph 45 of my brief, we cited the court's comments, and they're quite comprehensive and very rationally stated. And I'm going to summarize. He says the project's complete. The ordinance is adopted subsequent to substantial completion. There's no standing as a taxpayer here. The ordinance was never used with the project. There is no pending project. At most, it's a local dispute. It's not one of widespread concern. There's no allegations of bad faith or fraud. It does not involve public information, and I'll come back to that. There's no allegation of favoritism, corruption, or extravagance. And the actions did not supersede state law. The ordinance, he specifically determined that the ordinance 1257 does not supersede state law, and that any decision he would make would not guide future projects that might rely upon the new ordinance. It's not something that evades review. It is not a matter of competing authority of elected officials. And again, the city's never relied on the ordinance. There aren't a ton of Attorney General's opinions on the issue. In fact, there's one, and it's favorable toward the city. There are no competing district court decisions. And there are no Supreme Court decisions on this specific issue. The only project involving this particular concern was what West Fargo did. And I'm quoting him here, finally, the issue cannot reasonably be concluded as a controversy so unsettled the public policy demands a determination of the issue. And I'll highlight that. AGC wants to rely upon a forum communications case, which is an open records case. Every city, every county, every township in the state of North Dakota has records of one form or another. They are all subject to a request for production of those open records under Chapter 4404. But consider this. There is no evidence in the record that any city other than West Fargo has the equipment or the expertise or the manpower to do a mill and overlay project. Here's what a mill and overlay project is. And actually, you can read the AJC's declaration, which they cite to the Minnesota Department of Transportation. A roadway sits on a base, natural ground. In Fargo, eastern part of the state, it's pretty much permeable clay, not so much out west. Then you have a sub-base, and that's typically engineered. That's gravel or aggregate or something that's put in there to solidify. Then you have, in this case, asphalt. It could have been concrete, but in this case, asphalt. What a mill and overlay project does, it takes the top wear level of that roadway, that asphalt, removes it. In fact, the AGC's declaration says it can be as little as half an inch. You take that off, and you put down a new wear layer of asphalt. That's what your cars and trucks are driving on. That's what deteriorates. A reconstruction takes you down to the base. That's the removal of all asphalt, all wear course, and all subbase, or majority of subbase. That's not what happened here. In this case, the city of West Fargo interpreted the statute. I want to point out that what the statute says with regard to bidding says you have to bid the construction of a public improvement. But the definition of construction excludes routine maintenance. The Attorney General specifically has written in an Attorney General's opinion that the city relied upon, maintenance is defined using common terms. He used a dictionary term. He defined the term routine, again, using the dictionary. From that AG's opinion, the city of West Fargo said, we are going to adopt a policy for this particular project, and that is the work to be done here is routine maintenance. A mill and overlay project will occur periodically throughout the life of a roadway, depending upon the usage, weight, number of tire trips over it, and so forth. That's what the city of West Fargo did. They did it to preserve taxpayer dollars, which seems to be lost in this whole thing. We didn't adopt anything, including the subsequent ordinance, that directly contradicts state law, that is repulsive to state law. Instead, the ordinance that was adopted, which I'm going to tell you doesn't apply to this project. They couldn't have. It didn't come into effect until later. But if we want to talk about the ordinance, it's not a violation of any state statute or constitutional provision. There is no determination by the court as to whether it is or is not routine maintenance. But to suggest that the city was adopting this as a formal home rule power ordinance in an attempt to create a different set of circumstances than provided by state statute is incorrect. In fact, I would submit to you that the issue in this case, and I note that AGC puts it very broadly, puts the substantive issue in the context of whether or not the city acted in violation of the requirement for the publication and receipt of bids for a public improvement. If the court were to get into the substantive issue, I believe the issue is more precisely stated that may a city perform routine maintenance without bidding that portion of routine maintenance. And the Attorney General's opinion clearly says you do not. the cap doesn't apply, or statutory threshold, doesn't apply to routine maintenance.
Wouldn't that be a question of fact of what is routine maintenance?
I think it is. And in this case, the city of West Fargo made its determination. I understand that AGC disagrees with that determination, but there's no court record on that. So that leads me to the issue of mootness, which I think is determinative in this case. We have the Lorenzen case from 1922, never been overturned. And that was a project that was completed prior to the conclusion of the litigation. And this court, obviously with different members, ruled that that was moot. Would not advance forward with an advisory opinion. And that's what's being asked for here. In fact, I learned this week, and this is consistent with what Judge Brady determined, is that the decision in this case won't affect a future project or future issues if the city moves forward under its ordinance. And on Monday of this week, AGC, among other plaintiffs, brought a new lawsuit against the city of West Fargo with virtually the identical allegations. It's filed in Cass County. It's case number 09-2026-CV-01907. So to suggest that AGC 1, which did not involve the ordinance, somehow prevents the court from considering it when the ordinance was actually utilized by the city is false. We believe, with respect to the mootness issue, that this court has already posted guidelines, forecasted assistance to attorneys. In the Gosby case, the fact that the question might arise in the future is not adequate to establish public policy. The Pachigian case is one which I have personal knowledge and involvement in. Same thing there. That involved a local election, a local lot, a local park. And yes, it did involve action of the city council, but again, in that case, the record demonstrated no other city in the state had similar issues or concerns. The same as what was presented to the court in this case. We believe that the judge was correct in determining that the case was moot because of the completion of the project. He determined that there was no reason that there was a public interest, a great public interest that required action on the substantive issue. And for that matter, at the stage of a summary judgment motion, even had he proceeded, the city of West Fargo would have been entitled to all reasonable inferences in its favor, including that this was in fact a situation where there was routine maintenance involved. We believe that the Attorney General's opinion, 2012 L08, is entitled to deference. Now, I understand it's not binding on this court, but it is a well-reasoned, well-written opinion. And the whole question comes down to, does the phrase in that particular opinion, and it's defining the definition of construction under 4801.201, where they separate out that demolition projects costing less than the threshold do not require publication. But if it's more than a threshold, a demolition project would require it. That is in contrast to which the statute says the term does not include the routine operation or maintenance of existing facilities, structures, buildings, or real property. We believe the Attorney General's opinion is correct, well-reasoned, and based upon good law. And the Attorney General in that situation defined, using dictionary definitions, both maintenance and routine. We believe what this court is being asked for is an advisory opinion on a case that clearly is moot because of the project being fully completed. We are asking this court to issue its ruling affirming the dismissal and the entry of judgment of dismissal without prejudice and conclude this litigation. Thank you.
Thank you, Mr. Swanson. Mr. Surma, you have 10 minutes for your rebuttal.
Thank you, Justice McEvers. To pick up where Mr. Swanson left off, that this case is moot, I just want to reemphasize that the whole purpose of the public bidding statutes is for the benefit of the public, and that this case clearly falls within the public interest exception. These projects involve taxpayer dollars across the state, is not specific to West Fargo, and given that the public has a pecuniary interest, it should be decided. These issues should be decided.
Does it matter whether the record has information that cities other than West Fargo are capable of doing this sort of maintenance?
I don't think so, Justice Tufte. I mean, the record is absolutely devoid of any of that information. But I think any political subdivision is capable of doing it. It's a matter of whether they have the authority to do it or not. That's at issue, not who's capable. So I don't think that should be considered, and it's not in the record. Mr. Swanson cited the Gosby case for the proposition that issues that may arise in the future are not sufficient for the public interest exception to apply. But, I'd point this court's attention to Danzel and Foreign Publishing. In Danzel, the court acknowledged that, construction had proceeded and was well underway. Materials had been procured, contracts had been entered. But the court in Danzel said, and I quote, "In view of Danzel's lack of attention toward a remedy for Bismarck's violation of the competitive bidding statutes, we assume that his purpose in bringing suit was to have the invalidity of the proceedings by which the award was made adjudicated and determined as a protection to himself and the public against similar irregularities in the future." That's exactly what this suit is the purpose of this lawsuit is to ensure that going forward, there's guidance on what West Fargo and other political subdivisions can and cannot do as far as working on public improvement construction projects. And I think this court should also reject the notion that now that the ordinance is enacted, that's the authority that the city is operating under. Prior to the ordinance being enacted, the city was operating under 4801.2. So it still needs to be decided whether West Fargo has the authority under state law, regardless of the ordinance, to self-perform this type of work. Otherwise, let's say there's a situation where we're back up here. It's decided that West Fargo does not have the authority or that ordinance 1257 is invalid. West Fargo then goes back and does another project, reasserting that it has the authority under state law to self-perform. Then we're back exactly where we are now. So I think that, the public interest question involved here demands an answer one way or the other. I also want to point out that the district court below in West Fargo here today, puts a lot of emphasis on the ordinance, and that essentially we don't need to resolve the issues because now there's an ordinance that controls. But on the one hand, the court denied the opportunity to challenge the ordinance, and then in dismissing the claims relied on the fact that that ordinance exists without determining whether it's valid or not. And so I think that justice requires that, the issues are resolved on their merits on both issues. Finally, on the issue of who gets to define routine maintenance. Below and here again today, West Fargo is not cited anywhere in the powers granted to home rule cities that it gets to define undefined terms in state law. Again, that's a core function of the judicial branch and not of home rule cities. And I'll add that, the legislature meant something when it said routine maintenance. This court says that, when the legislature speaks, it means what it says. So clearly the legislature intended some type of meaning for the term routine maintenance in the statute. It did not just throw it out there for then West Fargo or other political subdivisions or state agencies to define. So it's this court's job or the district court's job to define what routine maintenance is under the statute as the legislature intended it.
We typically don't define it, we just say whether it meets it or not, and different cases help define it over time.
Under this particular facts, correct, Justice Barr?
Reach a definition. We make a factual determination, or the district court does.
Well, I think it's applied in its ordinary meaning and sense depending on the facts of the case, correct?
Mr. Surma, this action was brought as a declaratory action, and the relief requested was to enjoin the city from West Fargo, not only from that original project, but from future projects, correct?
Well, it was two parts. Yes, originally a declaratory judgment action to declare that West Fargo had violated 4801.2 by self-performing work on the 2290 project, and that further declaring that under the statute, West Fargo was prohibited from self-performing work on future projects that were similarly situated.
So is that another reason why this case isn't moot, is because you weren't asking for damages like monetary damages, you were asking for future relief? Correct.
Yes, the same relief that was decided in Danzel and also foreign publishing. At that point, the foreign publishing involved public records. The records have been turned over, but the court in foreign publishing said that, this decision is going to guide how public officials conduct themselves going forward. This case is going to have that same effect. I also want to address the 2012 Attorney General opinion. It was decided and discussed in the briefing. The Attorney General in that opinion said that under 4801.2, governing agencies cannot self-perform construction projects. That was the main purpose of the Attorney General's opinion. And then the Attorney General went on to discuss how routine maintenance is applied under the statute. And I want to read the statute. This was argued below as well, that I do think that the Attorney General erred in his interpretation of the definition of construction. Construction under the statute, 4801.201, subsection 4, means the process of building, altering, repairing, improving, or demolishing any public structure or building, improvement to any public property. The term does not include the routine operation or maintenance of existing facilities, structures, buildings, or real property, or demolition projects costing less than the threshold established under section 4801.201.2. So what the Attorney General said is that demolition projects exceeding the threshold are not exempt, but that routine maintenance of any amount is. And our position is that because demolition, the specific term demolition, is included in both the definition of construction and then later on when it is exempted, the only way to give meaning to the words projects costing less than the threshold is to apply that phrase to routine maintenance as well. That the last antecedent rule should not apply in that circumstance as the Attorney General applied it. Words, again, are meant to give, each word is intended to give meaning to, and this court will not construe statutes to give surplusage, and that phrase would result in mere surplusage.
Thank you for your arguments this morning, Mr. Surma and Mr. Swanson as well. This case will be taken under advisement as all cases are, and court is adjourned until 1:30 p.m.